Well, thank you. I'm Robert Schapiro. I'm Associate Dean of Faculty, and I teach here at the law school. And thank you all for being here this afternoon. I do want to again thank our main sponsors for this event, the American Constitution Society and Lambda Legal, in conjunction with the Georgia Lawyers Chapter of ACS, the Stonewall Bar Association of Georgia, and the Emory ACS Student Chapter in Igala, and also the law firm of Alston and Bird. In particular, I want to thank some of the individuals involved, Liz Seaton of the American Constitution Society, Daniel Schuman, one of our alums with the American Constitution Society, Judy O'Kelly with Lambda Legal, a lot of the students from Emory who were involved in this, and then our local organizing people, Professor Bill Turner, and some of the other people who work with us at Emory, Scott Andrews, Corky Gallo, Veronica Wright. Now, first, I have three events I want to make sure you know about. Immediately following my remarks, there's a reception outside sponsored by Alston and Bird. Later tonight at 8:30, the students of the ACS and Igala are hosting a post-reception reception at Einstein's in Midtown, and there are flyers outside about that. And then third, if you liked what went on today, you'll love going to the ACS National Convention, which is coming up in June. It's an annual event in Washington. Many of these people will be here to talk about these and some other fascinating issues. So with that, I just want to briefly summarize some of the themes of today. It's always a little dangerous standing here between you and the reception. So I'd like to say the bad news is I think there are 6 themes, but the good news is I'm just going to say very little bit about each of them. So here we go. One is judicial decisions matter. There's a big debate about how important are judicial decisions. Is it really worth focusing on? Is that really where important social change comes from? I think part of what we've talked about today is that judicial decisions certainly do matter. Bowers versus Hardwick mattered. It mattered to Robin Shahar, an alum of Emory Law School who lost her job at the Attorney General's office when it was revealed she was a lesbian. It mattered to others who were branded as being criminals. And that way it's clear that Lawrence mattered. It removed that stigma of criminality, and more generally it affirmed rights of equal justice, of equal citizenship. It made real the words of the 14th Amendment that all people born in the United States are citizens of the United States. 2, having said that, though, it's also clear that social movements matter. Right? Judicial decisions can help create and give strength to social movements, but it's social movements that make judicial decisions possible. Part of our discussion was what was the big change from Bowers to Lawrence. Certainly one important factor was that apparently a Supreme Court justice could candidly say that he thought he had never met a gay person in 1986. By 2003, that was impossible. How do social movements work? They work through people organizing. They work through litigation. They work in lots of ways. So is it judicial decisions or social movements? Yes. I think it's clearly both. A third theme that we heard a little bit about at the beginning, though not so much thereafter, was about the effect of international legal developments. The decision in Lawrence cited international law, international judicial decisions, and that's important. But I think we'd also think about larger aspects of international influence. This is one example of that. We hear a lot today about what's going on with the current Olympic torch relay and the way in which dissatisfaction with Chinese policy is brought to bear through that torch relay. We might remember that back in 1996, we had a controversy about the torch relay in Georgia. Cobb County had passed a resolution condemning the homosexual lifestyle, and as a result of that, the torch was rerouted so it wouldn't go through Cobb County. Some of the Olympic events were moved. So it's really not just legal developments internationally, but the way in which international pressure more generally can help affect domestic policy. All right. Fourth, we certainly know that federal law matters. That's what Lawrence is about. A lot of what we talked about also is the way in which states matter. Right? A lot of the future of this is in state courts and in state legislatures. Of course, it's not just about states. And one of the stories of Lawrence has been the interaction of state and federal law. We had Bowers. Then we had state court decisions, like the one in Georgia, holding statutes unconstitutional under state constitutions. Then we had Lawrence. And Lawrence, I think, certainly helped to inspire other state court decisions, like the Goodridge decision. And that kind of interaction will continue as people look to both the federal courts and the state courts to make real the promise of Lawrence. Right? Which leads to sense number 5, which is clearly elections matter. Right? Elections for the legislature, elections for state judges, many of whom are elected, and obviously elections for the President of the United States, who nominates all federal judges. And with that, we just might note that a week from Sunday, John Paul Stevens will celebrate his 88th birthday. Okay, and then finally, I am a constitutional law professor, so I guess one of the themes that I enjoyed was that the language of the opinions matters. Right? We can celebrate the decision in Lawrence, but a lot of what we talked about was, well, what does it mean? Is it really about a fundamental right? Is it really about moving away from tiers of scrutiny? Is it really about rational basis review? Is it really more about equal protection or about due process? And we see part of this, I think, to paraphrase Professor Carpenter, I could say that Justice Kennedy's opinion was long on poetry, but short on doctrine. Right? And we hear a lot these days about campaigning in poetry. I guess part of the problem is that justices write Supreme Court opinions in poetry, but then doctrine comes in prose. And that's sort of the problem that we're facing, is what do you do then about the poetry of the decision and how that's actually worked out in these lower court decisions. Well, with that, again, not to stand between us and our reception, I guess one could say that today we've been able to enjoy the logic of prose wrapped in the eloquence of poetry from our panelists. So why don't you please join me once again in thanking all of our panelists today. And with that, we are adjourned.